I'm standing to support Amendment 74 in particular, and the motivations have been well made by the Noble Lord, Lord Keane-Reilly. In a letter that relates to IPP prisoners that the Noble Lord, Lord Timpson, sent some of us at some point during the year, I noted down, and this does relate, by the way, there must be a clear reason to consider the early release of the prisoner before they have served the sentence imposed on them by the sentencing court. Thousands of open-ended IPPs, we are told, are incarcerated without a release date because they have to convince the parole board that they are safe enough to be released, all in the name of public protection. And the reason I'm raising that now is because there must be clear reasons to consider. People have to be safe before you release them. And yet here we have an early release scheme, an earned release scheme, in which even serious sexual violent offenders can earn their way out of prison, but you can't earn your way out of an IPP, which does seem to me to be rather inconsistent. We've already heard that earned progression, anyway, is not going to be earned. And if you actually read what's been written about earned progression, put forward by everyone from the Inspector of Prisons to concerned prison officers and unions and so on, the idea that they have got a consistent way of testing the earning capacity of prisoners inside to check whether they've reached they've earned their right to be free, I think is unlikely. It's going to be automatic, and that's been agreed. Now, I just think that we have to consider who we're talking about, because earlier on, when I spoke about the violence against women and girls strategy and my concern that we should be in a situation in which we were potentially making an exemption for non-custodial sentences for what some might call minor sexual offences or stalking or domestic violence, in a way, one was assured that one shouldn't worry. These were minor events. Who we are talking about here, whether we like it or not, let's be honest, are the people who are perpetrating, for example, child rape grooming gangs members. We are talking about rapists and people who have been convicted of sexual assault. And I think that in total, thousands of offenders who are sent to prison for serious crimes against, very often, women and children will be potentially leaving prison early. And I think that the public, broadly speaking, might find that disconcerting. I am not opposed to the concept or the principle of earning your way out of prison, or at least I think it's an interesting experimental idea. I don't think it's what's going to happen in our prison service, but I like the notion of it. I get all that. I also am not arguing in principle against any early releases, although I can't bear the fact that those early releases have been conducted on the basis that we haven't got room for people. I mean, I'd rather it was based on some kind of principle than some sort of like, oh, it's a bit overcrowded, what can we do? That seems to me to be the wrong approach. But I do think that it's perfectly proportionate, not in any way kind of like a mad lock 'em up and throw away the key, for this amendment to simply say there are certain categories of crime that will be not considered for this scheme. Fair enough as far as I'm concerned, and I genuinely think that the government should just simply accept this. Absolutely. I would really genuinely hope that members of the parties crossbench, Liberal Democrats, some backbenchers from wherever, will go along with this, because that's what happened down in the other place. I would expect it to happen here, because it's absolutely common sense. And it's also very, very important that we do not undermine trust in the criminal justice system or in the prison system by making a mess of this, by not, therefore, making this exemption work.